The president who reshaped the American judiciary now faces judgment from the institution he helped build. 3 justices appointed by Donald Trump, a 6-3 conservative supermajority, and a series of rulings that have begun to draw hard constitutional lines around executive power. The Supreme Court's recent decision blocking National Guard deployments in Chicago and Portland sent an unmistakable signal. The conservative majority is willing to rule against this administration when it believes the law demands it. Now, with decisions pending on tariffs, birthright citizenship, and the Federal Reserve, the president confronts the possibility that the most consequential defeats of his political career will come not from Democrats in Congress, but from judges who owe their positions to his own nominations. The collision between this presidency and the federal courts has been building since the first days of the second term. Within 12 months of inauguration, the Trump administration faced over 350 legal challenges to executive actions. That number exceeded the combined total of lawsuits against the previous 3 administrations during their entire first terms. The pace of litigation reflects not simply partisan opposition, but a fundamental dispute over the boundaries of presidential authority in the American constitutional system. For most of 2025, the Supreme Court navigated these disputes cautiously. The conservative majority handed the administration a series of procedural victories, allowing contested policies to proceed while full litigation continued. They ended universal injunctions, the practice that allowed individual district judges to block policies nationwide. They permitted deportations to third countries not specified in removal orders. They allowed workforce reductions at the Department of Education. On the shadow docket, where emergency applications are decided without full briefing or oral argument, the administration won repeatedly. But a pattern emerged beneath these wins. The court was delaying, not resolving. The most fundamental questions about executive power were pushed into 2026. The merits of birthright citizenship, the constitutionality of tariffs imposed by emergency declaration, the president's authority to fire Federal Reserve governors, these decisions were deferred month after month. Legal scholars noticed that the Supreme Court has a long history of waiting until presidents have lost political momentum before delivering major defeats. Truman's steel seizure was struck down in 1952, late in his term. Nixon's claim to presidential immunity over Watergate tapes was rejected unanimously in 1974, just before his resignation. Courts check presidents when the political costs of doing so have diminished. The first unambiguous defeat arrived just before Christmas. Trump versus Illinois concerned the president's attempt to federalize and deploy National Guard troops in Chicago. The administration argued that rising crime and threats to federal immigration enforcement personnel justified invoking 10 U.S.C. Paragraph 12406-3, a statute that permits federalization when the president is unable with regular forces to execute the laws. Governor J.B. Pritzker refused to consent. Illinois sued to block the deployment. A federal district court issued an injunction, and the Supreme Court refused to lift it. The vote was 6-3. Chief Justice John Roberts wrote for the majority, joined by Justices Sonia Sotomayor, Elena Kagan, Amy Coney Barrett, and Ketanji Brown Jackson. Justice Brett Kavanaugh filed a concurrence. Only Justices Samuel Alito, Clarence Thomas, and Neil Gorsuch dissented. The majority's reasoning was surgical. The statute requires that the president first be unable with the regular forces to execute the laws. Regular forces, the court held, means active duty armed forces. The administration had made no showing that active duty military personnel were insufficient to protect federal operations in Chicago. By invoking the National Guard instead, the president sought to convert an exceptional emergency power into a general domestic policing authority. The court declined to permit that conversion. The implications extended far beyond Chicago. Portland, Oregon had obtained a similar injunction blocking Guard deployments. Hours after the Supreme Court ruling, the administration announced it would withdraw troops from both cities. The defeat demonstrated that even a conservative court would enforce statutory limits on executive power when the textual argument was strong enough. Legal analysts immediately connected the Illinois ruling to the pending tariff case. Both disputes involve the same structural question. Can a president invoke emergency powers to pursue policy objectives that Congress never authorized? In the Guard case, the administration claimed crime constituted an emergency justifying troop deployment. In the tariff case, the administration claims trade deficits constitute an emergency justifying import taxes that could reach 50% or higher. The International Emergency Economic Powers Act of 1977 grants presidents authority to respond to unusual and extraordinary threats to national security, foreign policy, or the economy. For nearly 50 years, presidents used this power sparingly, primarily to freeze assets and impose financial sanctions on hostile states. No president before Trump interpreted IEEPA as authorizing sweeping tariffs on nearly every country in the world. In April 2025, Trump declared 4 national emergencies to justify his tariff regime. The first 3 targeted Canada, Mexico, and China. The fourth imposed what the administration called Liberation Day tariffs, a 10% baseline rate on imports from virtually all trading partners, plus reciprocal tariffs reaching 50% on selected nations and corporations. The stated rationale was that persistent trade deficits represented an ongoing emergency threatening the American economy. Multiple corporations and state attorneys general filed suit. The legal arguments were straightforward. IEEPA does not mention tariffs. The word does not appear anywhere in the statute. Congress has enacted specific trade laws that delegate limited tariff authority to the president under defined circumstances. The Trade Act of 1974 permits retaliatory tariffs of up to 15% for 150 days. The Trade Expansion Act of 1962 allows national security tariffs under Section 232. By bypassing these frameworks and claiming unlimited tariff power under IEEPA, the administration asserted authority that no statute grants. Lower courts agreed. In May 2025, the Court of International Trade ruled that the president lacks authority under IEEPA to impose tariffs. The District Court for the District of Columbia reached the same conclusion on constitutional grounds, holding that interpreting IEEPA to permit unlimited tariffs would violate the non-delegation doctrine. Congress cannot delegate its exclusive constitutional power to levy duties without providing an intelligible principle to guide executive discretion. IEEPA contains no such principle for tariff setting. The Supreme Court expedited the case and heard oral arguments on November 5, 2025. The session lasted over 2 hours. Court observers reported that justices across the ideological spectrum expressed skepticism of the administration's position. Justice Neil Gorsuch, a Trump appointee, warned that upholding the tariffs would create a one-way ratchet of congressional power to the president. Justice Amy Coney Barrett pressed the government lawyer on whether any limiting principle existed. If trade deficits justify emergency tariffs, what would not? Solicitor General D. John Sauer argued that courts should defer to presidential emergency declarations. The justices appeared unconvinced. The Constitution assigns Congress the power to lay and collect duties. If presidents can impose tariffs unilaterally by declaring emergencies, the congressional power becomes meaningless. Any future president, Republican or Democrat, could bypass the legislature on any trade issue simply by labeling it an emergency. The ruling has not yet issued. Court watchers expected it in early January, then mid-January. Each scheduled decision day has passed without resolution. The delay has generated speculation. Some analysts believe the court is divided and struggling to reach consensus. Others suspect the majority is crafting a broad opinion that will definitively limit emergency powers. The longer the court takes, some observers note, the more likely the ruling will be significant. Treasury Secretary Scott Bessent stated publicly that he believes it is very unlikely the Supreme Court will overturn the tariffs. Administration officials have signaled they will impose new tariffs under different legal authorities if IEEPA is struck down. Section 232 national security tariffs remain available, though they require an investigation and finding that imports threaten national security. That process takes time. A Supreme Court defeat on IEEPA would disrupt the president's entire trade strategy, at least temporarily. The stakes extend beyond trade policy. The tariff revenue stream has become central to administration budget projections. Trump proposed increasing military spending from $1 trillion to $1.5 trillion, explicitly citing tariff income as the funding source. If the Supreme Court invalidates IEEPA tariffs, as much as one-third of that proposed budget increase disappears. Defense contractors watching the case have seen their stock prices fluctuate with each hint about the court's direction. Wall Street has priced in an expectation that the tariffs will fall. Importers are positioning for potential refunds. The Court of International Trade has already signaled it is prepared to issue implementation orders immediately upon a Supreme Court ruling, including instructions to Customs and Border Protection on reliquidating entries and processing refund claims. Companies that filed early protective lawsuits may receive billions in refunded duties. The tariff case represents the most direct challenge to presidential economic power in decades. But it is not the only constitutional confrontation heading toward resolution. On January 21, 2026, the Supreme Court heard oral arguments in Trump v. Cook, the president's effort to fire Federal Reserve Governor Lisa Cook. The Federal Reserve Act permits removal of board governors only for cause. Trump fired Cook anyway, citing allegations of mortgage fraud that predated her appointment. Lower courts blocked the firing. The Supreme Court refused to lift the stay while agreeing to hear full arguments. The implications for monetary policy independence are profound. If presidents can remove Federal Reserve governors at will, the central bank's ability to make unpopular but economically necessary decisions becomes compromised. Interest rate increases, inflation-fighting measures, financial stability interventions, all could become subject to political pressure from the White House. The consequences would reshape global confidence in American monetary institutions. Justices at oral argument appeared reluctant to grant the president immediate authority to fire Cook. But their questioning suggested they may avoid resolving the broader constitutional question. A narrow ruling could return the case to lower courts for additional fact-finding on whether the stated cause for removal was legitimate. The big questions about presidential power over independent agencies might wait for another day. Then there is birthright citizenship. The 14th Amendment states that all persons born in the United States and subject to the jurisdiction thereof are citizens. For over a century, this language has been interpreted to grant automatic citizenship to children born on American soil, regardless of their parents' immigration status. Trump signed an executive order purporting to end this practice for children of undocumented immigrants. Every federal court to consider the order has ruled it unconstitutional. The legal consensus is overwhelming. The Supreme Court addressed the issue in 1898, holding in United States v. Wong Kim Ark that a child born in San Francisco to Chinese immigrant parents was a citizen by birth. The 14th Amendment's text and history support no other reading. Yet the administration persists. They argue birthright citizenship was intended only for formerly enslaved people and their descendants, not for all persons born in the country. This interpretation contradicts the amendment's plain language and the Supreme Court's precedent. Legal scholars across the political spectrum have described the executive order as constitutionally indefensible. The Supreme Court will hear the merits this term. A ruling against the administration is widely expected, but the case matters beyond its likely outcome. The willingness to issue an executive order directly contradicting settled constitutional law reveals an approach to presidential power that treats legal boundaries as obstacles to negotiate rather than limits to respect. The pattern continues in smaller cases that have drawn less attention. On January 12, 2026, the District Court for the District of Columbia ruled that the Department of Energy violated the Constitution's equal protection requirements when it cancelled clean energy grants based on whether recipients lived in states that voted for Trump. The court found the administration freely admitted it made termination decisions based on electoral support for the president. Punishing citizens for living in states that voted against the administration represents viewpoint discrimination of the most basic kind. The president has lost cases involving foreign students whose visa registrations were terminated, independent agency officials he attempted to fire, federal workers he sought to dismiss, and deportation procedures that violated due process. The litigation tracker maintained by Just Security documents hundreds of legal challenges. The administration has prevailed on many procedural questions, particularly involving the scope of injunctive relief. But on the merits, the record is increasingly unfavorable. The question now is whether these defeats will constrain executive action or simply provoke defiance. When the Supreme Court blocked National Guard deployments, the administration withdrew the troops. But other court orders have been met with resistance. Lower court judges have complained that the administration ignored or delayed compliance with their rulings. The Justice Department's Civil Rights Division reportedly declined to open investigations that career prosecutors recommended, prompting resignations. The dynamic creates a constitutional stress test. Federal courts issue orders. The executive branch decides whether to comply. Traditionally, compliance has been assumed. Presidents might criticize judicial decisions. They might pursue legislative overrides or constitutional amendments, but they obeyed court orders. The alternative, executive defiance of judicial authority, risks a constitutional crisis with no clear resolution mechanism. Trump has attacked lower court judges who ruled against him in language unprecedented for a sitting president. He has described them as radical, unhinged, and enemies of the American people. But he has largely restrained his criticism of the Supreme Court, even when he lost the National Guard case. The conservative majority represents his own legacy. 3 of its members owe their positions to his nominations. Attacking them would expose a rift within the coalition that elevated him, yet that coalition is showing strain. Barrett and Kavanaugh have now voted against the administration on significant questions. Gorsuch has signaled concerns about unlimited emergency powers. The conservative legal movement that championed these nominations emphasized textualism and separation of powers. Those principles do not disappear when a Republican president exceeds statutory authority. The coming weeks will bring clarity. The tariff ruling could arrive any day. Birthright citizenship will be decided by June. The Federal Reserve case will resolve the immediate question of Lisa Cook's status and may address broader questions about presidential removal power. Each decision will either confirm the boundaries of executive authority or expand them dramatically. The outcome matters beyond this presidency. If IEEPA tariffs are upheld, future presidents will possess nearly unlimited authority to impose trade barriers by emergency declaration. If birthright citizenship can be reinterpreted by executive order, Constitutional rights become contingent on presidential discretion. If Federal Reserve governors can be fired at will, monetary policy independence ends. The conservative legal movement spent decades arguing that courts should check presidential overreach, that the Constitution establishes separated powers for a reason, that emergency authorities must have limits. Those arguments did not distinguish between Democratic and Republican presidents. They rested on structural principles about how government should function, regardless of who occupies the White House. The Supreme Court is now being asked whether those principles apply to this president. The justices Trump appointed are being asked whether their judicial philosophy constrains only presidents they oppose or whether it binds all executives equally. The answer will define this court's legacy and shape the presidency for generations. The president built what he believed was a judicial firewall, judges who would rule in his favor when challenges arrived. He is discovering that judicial independence means something different. It means judges who interpret the law as they understand it, even when their conclusions displease the president who nominated them. It means a Supreme Court that defers to precedent and text even when doing so creates political problems for an administration. The system is working as designed. Courts are reviewing executive actions. Some survive scrutiny, others do not. The Constitution's limits are being tested and, in at least some cases, enforced. Whether this continues depends on decisions yet to come. But the trajectory is clear. The most conservative Supreme Court in nearly a century has begun telling this president no. The question is whether he will listen.